All right, I'm Jon Rehm, and welcome to the inaugural video blog of Nebraska Workers' Compensation Watch, which is essentially going to be a YouTube or a Facebook Live and show, as well as a podcast, once we get all that figured out. And what it is just going to be a discussion among the lawyers here at Rehm, Bennett, and more about various issues in workers' compensation and things that are of interest and use to people who get hurt on the job here in Nebraska and in Iowa too, because we represent people in Iowa. So anyway, I'm just going to go around the room and introduce everybody. Everybody talked to me. So I'm Jon Rehm, and over here who do we have? Looks like we have Rod Rehm here.
Hi, I'm the old guy here, and started the firm back in 1987. We've been representing hundreds and thousands of injured workers since then, and have a really good group of people. I'm going to pass myself along to Roger Moore, who's sitting in front of our front window in our Omaha office.
Howdy, I'm Roger Moore. I'm comic relief, and I'm the good-looking one of the bunch. So
yeah,
right.
That's great. Yeah, your background that looks like one of those Zoom backgrounds. It looks like you could have like the Golden Gate Bridge or like a beach out there. So
we should patent that. We should patent it and sell it on the line, maybe.
Well, let's go viral. So anyway, so let's get. The other lawyer in our firm is Todd Bennett, and I don't know where he is. He's on the phone. So, but he'll be in other chats. So anyway, I'm going to get started here. And for our inaugural episode or broadcast or whatever this is, I guess the thing that I want to talk about is what's the most important thing that if somebody gets hurt on the job in Nebraska or in Iowa, I mean, Roger, you can talk about Iowa, but in Nebraska, what's the most important thing to do when you get hurt at work? And I'm going to lead off, and I am going to say the most important thing, in my opinion, to do is to tell somebody you got injured as soon as you can. And by somebody, that means a boss, and that means a doctor, when you go seek medical treatment. And the problem that I see with people who don't report things, what happens is they don't get claims opened. So they go to the doctor and things get either put under private health insurance, and they don't get paid, and the bills pile up, and they're off of work, and then they're not getting paid because it's not workers' comp, and then their leave runs out, and then they're getting fired, and they want to claim maybe they got fired for getting hurt at work, but since you never claimed workers' compensation, you don't have a case there. So I think telling your boss and your doctor is one of the most important things, and a lot of people are afraid to do that because they're afraid of getting let go or being fired, which is illegal in Nebraska, in Iowa too. But it's almost like it's a self-fulfilling prophecy. If you don't tell somebody, then you end up getting fired anyway. The fear of the injury and of what happened works against people. So that's one of my biggest things that I think is this is off the top of my head that's the most important. So Roger, Rod, one of you want to chime in?
Go ahead, Roger.
Well, I'll add to that, and I'll say it's not just important to tell somebody, because so often in our practice we see that people come in and they say, I've reported to my supervisor, or I went to the nurse or HR, and they haven't done anything. So it's really important to actually do some kind of written documentation with someone, as far as just not telling someone, but writing it down and having some written documentation. And in Iowa, there's a specific prohibition that if you don't report the injury within a specific time frame, you can never bring the claim in the first place. So it's very important in Iowa to make sure you reported it. So many employers won't file claims right away, we found in our practice. And so if you're not getting any feedback, if they're not letting you fill out the paperwork, I think it's more important to go see a doctor very soon after the injury, because that will trump the lack of reporting, because there's some documentation of the injury happening as well. Rod, go ahead.
Along those lines, a lot of employers and employees communicate via email or even text anymore. It seems like that's pretty common practice. And that's a real easy way to document that you've given notice and that something is up. is to just bang out an email or a text, depending upon, you know, how you communicate electronically with your boss, and that gets the stage set, you know, so for you to get compensated. Because and this whole thing about informing somebody, I think it's really important when you go to the doctor, that if you think this has anything to do with work, that you tell them that. I mean, that's John talked a minute ago about people being fearful, but you know, if nothing shows up in medical records about what happened or how it happened, that's a big problem. That's very hard to overcome. So try to do that. My most important thing, I think, is a little different than John's. I think an employee that's hurt should make a really hard, concerted effort to keep some records of what was going on, to keep their medical notes from the doctors, off work notes, get a copy of any employer forms you fill out, so you have documentation, because the insurance companies have a responsibility to pay claims, but their responsibility is to pay valid claims, and they have a whole checklist of things that they expect in order to start paying your workers' comp benefits.
Roger?
And I'll say too that you know, we understand that it's not always easy to report the injuries. We understand there's some fear about being disciplined or terminated if you report the injury, but if you don't, and people expect that, the judges don't understand the lack of reporting of an injury, because they think, well, workers' comp is out there. People know that it's out there. People know it's a benefit. They don't understand the gap in reporting an injury. It doesn't hold any water with them. So as tough as it is, and as fearful as you might be, it's always better to report it than not, because if you don't report it, you're not going to be able to unring that bell later on.
Yeah, and to some extent, you know, I've heard judges at conferences talk about, you know, particularly if injuries come on through overuse or repetitive overactivity or repetitive use, if something starts hurting and then it doesn't go away, and then maybe you wait a week to go to the doctor or something like that, or a little bit of time before things get bad. I've heard judges say, yeah, they understand maybe waiting a couple of days to go to the doctor before something happens, because people think things are gonna go away. But the longer the delay, the tougher it is. Hey, and it looks like we just got Todd Bennett waiting to be admitted here. So I'm admitting Todd Bennett to the podcast here. We're waiting for him. All right, Todd,
Hey.
you there?
There we go.
All right.
Yeah.
So Todd, the question is, if somebody gets hurt on the job in Nebraska or Iowa, what's the most important thing that you think that they should do?
Well, the most important thing is to make sure they inform the employer in writing, preferably, or have a witness or a medical restriction note or notice of injury that they can provide the employer, the HR, a union rep, or frankly, just any witness. Yeah.
Yeah.
Yeah. So,
The yeahs were really informative here.
great. Todd,
Well,
Rod, and
yeah.
I brought that up too. That was mine, and that was my lead off. Rod also talked about the importance of keeping track of company documents and work restrictions from doctors. Can you speak to that a little bit?
well, if you remember, we used to have our all little orange folders where we would hand them out to workers to make sure they keep the restrictions on themselves. So that way they can provide it to their employer, their supervisor, and make sure they have a copy of their limitations at all times in case they're asked to do anything above them or outside of their restrictions of what they think they're able to do.
Yeah.
I think that's important, and we haven't done that for a while, but it's always kind of nice to refresh that because it's still think that's a pretty good tool that we gave people.
Well, this is a side benefit of doing these discussions is we'll probably talk about things that we should be doing to do our job better, and we may have to get those that project back going again. That's a good idea.
Yeah, I've had plenty of water hit this, and it's still the label has not worn off. So
Well, the idea is to have your work restrictions in a waterproof container, so if your worker gets wet from sweat or whatever, that they've always got those restrictions there to protect them from being, forced to do something that hurts them further.
That's exactly right.
Yeah.
One other thing about, once you report the injury, assuming they take the information down and you've got it documented, a lot of workers sometimes will wait on the employer to set up an appointment. And sometimes that's days or weeks. So don't feel like you have to wait on them to set an appointment up for you. If you've reported it and are requesting a doctor's appointment and they haven't set one up for you, then you just go to your own doctor or go to any doctor just to get the process started.
And with insurance, the one thing that I tell people a lot, there's primary insurance and secondary insurance. I mean, and some people don't even have health insurance. I mean, unfortunately, that's a lot of people that get hurt at work. I mean, I think it's a significant minority, but the primary insurance is workers' comp. And then the secondary insurance would be any health insurance that you would have either through the job or through a spouse or a partner or a family member or whatever. So, I mean, there's always primary and secondary. And the other thing too is when you don't get claim information, you can get claim information, insurance information from the Nebraska Workers' Compensation Court, 402-471-6468. And I think there's an 800 number too. You can call them and ask them, who's my employer's workers' comp insurance company, and they'll tell you that. But yeah, you can go and make an appointment. The sad thing is, though, sometimes there's some plants that try to scare people, particularly in meatpacking, I've seen, that try to scare people from making appointments on their own or making appointments without permission. I mean, have the other three of you experienced that or seen that in your cases?
I think that's pretty regular. They want to control medical, and they're going to use every tactic they can to control it, monitor it, and frankly, not incur the charges. Which is ironic. I'm looking at our yellow card, and when we get back to what's most important, you got to make sure you tell them exactly how you got hurt, when you got hurt, and when you say primary and secondary, what's your main problem, but don't forget about your secondary problem or injuries that are giving you pain, not just the one that you're hurt the most. Because most often than not, those secondary injuries become the most important later on down the road.
And sometimes those injuries don't even get recorded for years. I had a trial this week where it was 2 years later, they found out that my client broke his foot. And I mean, there's just crazy stuff. Or oftentimes, if it's a wrist injury in a shoulder, in an elbow injury, it's really a shoulder injury or a neck injury even. So yeah, don't forget it. And do you guys also find that employers want to just treat one body part rather than multiple body parts?
Oh, absolutely. I think that's their key of shortchanging the injured worker, but it's also the key of monitoring and controlling the exposure, but also getting out of an injury that they should respectfully be paying for.
Even if you see a doctor and the doctor says, well, I can only treat you for the shoulder, or that's all I'm authorized to treat you for, doesn't mean you can't bring up the other injuries and other issues that you have with that doctor. And again, if they're not allowing you to see the doctor for all of the injuries that you have, then go see your own doctor and document it through them, because we do see a lot of that where the employer says, well, I can only see him for this injury, and they've got 3 or 4 other complaints that are out there, and they just don't talk about it, and those get, swept under the rug, and months later, it's tough to bring them back up again.
Workers' comp, I think, to injured people should be simple, and I agree with that, but it's not. And a lot of steps or checklist items need to be met in order to make sure you get paid properly. And, you know, I suspect that as we go forward with this project, we'll be exploring different things that are common problems. And Todd's talked about our cards. I don't have any with me, but in our offices, we give out some real informational cards.
There you go, Robin.
Yeah, you know, one of them says what to do when you get hurt. And it's a little larger checklist than we've talked about here today. I think there's 14 items on that that we struggled to boil it down that much. And then the other one is, when should I hire an attorney? So, you know, those are available on our website, and we're going to be going through that list, I think, for some period of time, because I mean, it's not as simple as it should be for the worker.
No, it's not. And you know, the issue of, let's say you have a wrist and an elbow problem and you're only treating for your wrist, and in the company won't let you treat for your elbow, and you go see your doctor for your elbow. I mean, in Nebraska, and I don't know how Iowa doctor choice works, but if you elect to see a doctor and you just go see a doctor on your own, sometimes that creates another hurdle for, if you go see a doctor on your own, sometimes to get paid, to get that paid under our workers' compensation rules, you know, because if you don't ask for permission or ask to change doctors, sometimes medical care can get denied, even if it's ultimately related back to the work injury. So, but again, workers' comp should be simple, but it's not. So, and I think mostly it's employers and insurance companies that make it harder than it needs to be. So, Todd, Roger, you're our Iowa lawyers. What are some of the maybe pitfalls of doctor choice in Iowa?
Well, the pitfall is you start out behind the 8 ball because the employer gets to control. They have a right to control. And then the pitfall becomes, if they deny compensability, you're free to choose, but then you got the practical problem of, is your health insurance going to pay? They should in Iowa, because ironically, there's a specific statutory mandate that the employer has to work with the health insurance, and if they're denying the work comp claim, they have an obligation and duty to make sure the health insurance actually pays for the treatment that they claim is not related to the work accident. But what is your experience, Roger, when you got a physician choice problem in Iowa?
Yeah, it's tough. At least in Nebraska, you can elect to see your family doctor and have them control your medical care. But in Iowa, you really are kind of at the mercy of the insurance company. You have some alternate care options, but not many that are very viable. I had a case earlier this year where they denied the case from the start, and even the health insurance hadn't processed the medical bills. I had to sue the health insurance in federal court in Iowa to get them to pay the benefits on a denied claim when it was clear from the start that they denied the claim. So getting back to the main option, that it's not always easy. Sometimes you have to document the denial with the insurance company before they'll pay the medical bills. Got one here in Nebraska right now that just got resolved. Work comp had denied it, but because of an error they made in some admissions, we had to go back and kind of clarify that they denied the claim to get the insurance company to pay it. So the documentation is key in a number of different respects, not just with work comp.
You know, I think the big point that is here is that people may not understand that if you have a work injury and it's denied, and you also have health insurance, the health insurance has to pay that bill if it's denied and if it's reasonable care. And they're not as picky and tricky about what doctors you go to. So in some respects, it's much easier to get full care if you're unfortunately denied workers' comp.
Yeah. And then it's actually, you know, when we talk about people like Nebraska Orthopedics or several of these orthopedic outfits where even though the comp has denied the claim and they're not willing to pay for care, certain providers won't allow you to use your health insurance, not until they get approval from the work comp carrier, which has become another practical hurdle. You know, in Iowa, you get the option of filing you heard the term medical alternate care. And as long as you get the employer to deny the claim, then you're free to choose and use your health insurance. And that's kind of the difference between Iowa and Nebraska. Iowa, you at least got kind of that statutory duty where the employer has to work with you to get the health insurance to pay. We don't have that in Nebraska, but you at least have that option to use it if they're willing to accept it.
Well, I'm the Nebraska licensed only. The one thing that one of our strengths is if you have to have surgery, you can always pick your own surgeon under Nebraska law, which is, I think, you know, a really good provision, because you know, we should trust who's going to put us under and cut us open, and be allowed to pick who does that. And fortunately, we still have that in Nebraska.
Yeah, and that's a good point, because still, even today, 20, 30 years later, people still don't understand that they still have that right.
Right.
Because it's so inbred where everybody's told they can't choose and they can't pick. But if you have that major surgical operation, you can choose your surgeon, which is one of the best things in you know, the last several years of the legislative changes we've had. And thank God we still have that.
You think,
I think
nurse case
some-
managers in Nebraska tell people they can pick their own surgeons?
No, actually, the gentleman I had here in the office yesterday simply came to us simply because of that issue, where the case manager went to a family doctor in Hastings and said, no, we're not going to let you treat him, but sent him to Omaha to their doctor.
For the
Which is
uninitiated,
illegal.
what's a workers' comp case manager, a nurse case manager?
Well, they're hired by the insurance companies to try to manage the health care that an injured worker gets, and they say that they're doing it for good reasons. And our experience is that many of them, at least, just do it to reduce the amount of health care and get people sent back to work before they're ready to go back to work, because it saves workers' comp.
And to be even a little bit more blunt with it is, you know, even the Nebraska Supreme Court says they're just the right hand of the person deciding your case, deciding whether they're going to approve care, deciding whether to pay a check. And they're not a benefit for the injured worker. But it's funny, because the gentleman that I talked to yesterday, gets the story. I'm just here to help you coordinate your medical care, and I'm your friend. And lo and behold, he gets shipped out of his own dock and shipped to Omaha. Next thing he knows, it's a year later, and he still hasn't had surgery.
Yeah.
So,
Roger, you haven't been saying anything. That's kind of unusual.
Yeah. Well, I was going to say that I think a lot of people that are injured on the job kind of trust their employer to send them to doctors that are good, that have their best interest. But unfortunately, that's just not borne out in practice. There are lots of reasons to send employees to doctors for treatment and for surgery that have absolutely nothing to do with the medical care that's there. I mean, you get doctors that do surgery and send them back to work the same day or the next day. You get doctors that give crappy ratings or no ratings after the surgery is done. And those are the things that are important to insurance companies, not to get you to a doctor that's going to get you a good result. They're trying to save money at the end of the day. From the day the case was reported until it's completed, they want to spend as little money as possible on that claim. Those are the things they're worried about, not about getting you to a good doctor who's going to treat you fairly and put you on reasonable restrictions both during the recovery and afterwards. So it's easy to think that the employer has your best interest at heart, but in practice, that's not the reality from our standpoint.
No, it's not.
Well,
And Rod, what if an injured worker gets the letter that they're being sent to a doctor they don't even know, but the insurance company's just scheduling an appointment out of the blue?
Well, I mean, it depends upon the status of the case. I mean, they kind of have a right to do that, unfortunately, for what's called an independent medical exam. And it's a very upsetting to workers. But sometimes, and probably most of the time when they do that, they've got the right to do it because of the way the law is written.
Can they refuse to go?
Well, you know the answer. Why don't you tell me?
You definitely cannot. And frankly,
I was role playing there, man.
Yeah, well, that's okay. I mean,
Professor Bennett.
yeah,
the problem is that the insurance companies write the checks, and so they've got this economic power over the injured worker that if if you don't go along with them and let them do certain things, they're just going to stop paying you.
Well, by law, they can stop benefits if you refuse to go to one of their exams, or even if you
it's reasonable.
medical treatment they
It's
offer.
reasonable.
Stop paying you money.
Only if it's a reasonable request. But
Sure, but I mean that's reasonable is determined by a judge. So I mean, it's no guarantee that it's going to be found to be unreasonable. I've had to fight the medical exam issues a few years ago with somebody they examined like twice in 4 months, and I asked the judge how many exams do they get, and the judge said as many as they want. So, and it's hard to fight those medical exams, and they're not second opinions. That's another thing is you hear from, the clients will tell us, well, this nurse case manager sent me to a second opinion. No, it's not a second opinion. I guess it's a second opinion, but it's not it's their own opinion. So, I mean,
it's not independent, that's for sure.
yeah,
Right.
well, even though it's called independent. So
well,
anyway,
as you
we're running
all
up
know,
against 30 minutes here. Go ahead.
I had a case recently where an insurance company paid one of these independent doctors $14,000 to write a letter because there was a lot of medical records. They sent him a couple thousand pages of records. He claims that he read every single one of them and billed him $14,000 to say that a kitchen worker wasn't hurt.
Right.
So, I mean, it's kind of a tough world out there for injured people.
How much was the kitchen worker making?
$8.25 an hour.
Yeah.
It's
Wow.
crazy.
Well, and I think it's more important there's nothing independent, as you said, where if you're upfront and realize it's a defense, it's an insurance exam, then people need to understand this isn't someone who's unbiased. These people are biased. They're being paid by the person making the decision in the case. Now, sometimes you get lucky, but that's about 5% of the time if you're lucky.
Right.
Yeah, definitely. If you get a letter from the insurance company about one of these exams, that's a good time to call an attorney. And just to kind of follow up on that, you can call us and talk to us about your case or questions you have for free. A lot of people still don't understand that we work on a contingent fee. So there's no charge to call us and talk to us about the case at all.
Right.
We're happy to give you the information about the injury and tell you what we think.
Sure.
So
All right.
There's an old saying, knowledge is power, and there's a lot of rules and a lot of blind alleys and a lot of checklists and a lot of hurdles that are out there to make something that should be very simple difficult at times.
Okay. Hey, we're running up against our time. So anything else anybody wants to add?
I vote we do this again sometime.
All right. Sounds good. I like this. All right, guys. Until like Maury Povich on Current Affair used to say, until next time, America. All right.
Yeah, but be careful out there.
Yeah.
stay classy,
All right.
America.
Stay classy, America.